Your name, ma'am?
Summer Greathouse.
Mr. Longton, your appearance? I need to read you both something that was handed me today. And I'm not trying to create any more problems here for her and her ex-husband or estranged husband. But I need to read this to you because I'm not going to conceal anything, obviously. He just says to whom it may concern. Who am I hearing right now, Heather? Can you tell me?
I believe it's the jail background noise.
Okay, I'll keep my voice up nice and loud. I am writing to you as the sole legal property owner of the residence located at 30,001 Huron Meadows Drive, Rockwood, Michigan 48173. I'm aware that the defendant, Summer Greathouse, is currently serving a jail sentence under your jurisdiction and has an upcoming court hearing. Please be formally advised of the following. 1, no consent for tether/ankle monitor location. I do not consent to my property being used as a designated residence, base station location, or monitoring site for any court-ordered electronic tether, scram device, GPS tracker, or house arrest equipment. 2, revocation of residency effective immediately. Summer Greathouse does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number 3. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. 4, clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court. Specifically during her prior bond violation hearing, I'm advised that she may attempt to claim her immediate release is necessary for child care. The children are completely safe, stable, and cared for in my custody. Her claims of child care hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so that her defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file. Respectfully submitted, Harrison Steves. So with that,
I respond to that.
you can respond whatever you want.
I realize there's a lot of falsehoods in there.
Hang on a second. Hang on. You asked for a hearing. You filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late SoberLink blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was, or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
Well, what he's done. Trying to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
Yeah, that's correct, John. You did not. But I wanted to make that clarification. But I know my client is delighted with me to address which you read in the record of that letter.
Okay, okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an ex parte order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary custodian of this children since birth. The biological father, the never married mother, has not been a primary caregiver, not been the cause. He's seized on this. If we grab custody, and I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you? Is that you, Mr. Are you Mr. Steves? Are you Mr. Steves?
Yes,
Okay, he's in the back. Go ahead.
I have no doubt that these children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can carry to by her own. That's what I'm asking. She has learned her lesson. There's no doubt in my mind she has learned her lesson all about honesty with this court and fucker.
Can't lie to the court.
Your Honor,
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I tell that. And you tell me.
Your Honor, may I
It just
speak?
underscores how she has not taken this seriously. Listen,
Your-
I wanted to give you this hearing only because I wanted to clear up this record. I did
Yeah.
not say anything about bond conditions. That is
Yeah.
not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program if you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No,
My-
but you can't just say I can commit all these crimes.
At this point, the judge is making it clear that the issue isn't just one mistake. The court's concern is a pattern of dishonesty and repeated violations. While the defendant is asking for another chance and emphasizing her role as a mother, the judge believes trust has already been broken too many times. In cases like this, credibility can be just as important as the underlying offense.
And then say, I want to put it behind me.
I will
This is
not.
the thing. This isn't a simple, isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people through sobriety court who are not being honest with me. I will not do that. I'm sorry.
Will
The
not
motion
have
for
a
reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day. But are you ready on Shores Financial? Mr. Runyon, you ready?
Yes, I'm ready, Your Honor.
I feel sorry for Ms. Ratliff and you. Shores Financial versus Scott Ratliff, 21F1466. All right, how you doing, Mr. Runyon? Your appearance again?
Thank you. Your name, sir?
Justin Heaton.
And sir, you were intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of things. First of all, there is some danger in representing yourself. You'll be held by the same standards as an attorney in courtroom. The court is not here to assist you in that manner. I will presume that you would know the court rules and the manner and procedures. You understand that, sir?
Yes, Your Honor.
All right. I do also have to advise you that you're here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right, what would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court to decide that. Yes.
On the court.
To decide the next procedure.
Sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay.
Okay, what?
No, thank you.
Okay.
Now we're seeing a completely different situation unfold. This defendant has chosen to represent himself, but it's becoming obvious that he doesn't fully understand the legal process. The judge is repeatedly giving him opportunities to seek legal counsel, recognizing that self-representation can be risky. It's a reminder that having the right legal guidance can make a huge difference in court.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to my best wishes.
The next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed.
Pardon?
Proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the
Your Honor, our office has not really been able to deliver discovery. We would be asking for at least one of the jurors to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request proper paperwork before today. Yes.
You requested it from whom?
From the jail upon
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today,
At any point. Sir, I'm going to ask you again. Do you wish to be represented by an attorney?
no.
All right. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit. We'll find the one.
Well, I'll give you two, because they're gonna have to arrange a way for him to look at it, and I don't. Probable cause conference, court's gonna find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 AM. Bond in this matter will continue. Thank you. So that we're clear on denying the request to release the defendant at this time.
This hearing highlights two important lessons. First, honesty and accountability are critical when appearing before a judge. Second, navigating the legal system without preparation can create serious challenges. Whether you agree with the judge's decisions or not, today's courtroom proceedings show how credibility, responsibility, and understanding the law can significantly impact the outcome of a case.